Many people often wonder the process of a lawsuit and the different stages and how do you get there. We call this the anatomy of a lawsuit. It starts with intake. Intake is the process where you contact the office, you speak with paralegals or myself. I always make the phone call after I get the initial information from the paralegals about the case and why you are calling. And generally, it's because either someone is injured still, something happened, they are in the hospital, they're trying to get out of the hospital, they've had subsequent surgeries. One of their loved ones has suffered permanent catastrophic injuries, such as brain damage or a paralysis or a spinal cord injury, or someone has passed. So the intake process is learning about your case, what has occurred with the individual that you're calling, where did these things occur? If it's a wrongful death case, we figure out wrongful death, meaning one of your loved ones passed away. We have to figure out where that occurred, why it occurred, etc. Obviously, there's information the client can only give to us initially, but then we do a different process called investigation. In the intake with respect to wrongful death, there will be a detailed examination on the phone with the potential client about what exactly happened, what do you believe happened, was there an autopsy, and why does that matter? Because a lot of times defense lawyers will try to say that's not why the person died, so autopsy is always very helpful if it can indicate exactly why the person did pass away in the hospital, if there's any question as to why the person passed away in the hospital or after the hospitalization. And then we also, you also have a death certificate, which is something that we need so we can have in our file and we can open up the case. With wrongful death cases, you have different beneficiaries by statute that are entitled to recover as a result of the person's death. So there are two different, we call them causes of action. Causes of action are the types of action, what is actionable as a result of the death. You have the survival action in the wrongful death suit, and the survival action is the pain and suffering of the person who is now dead from the time of the negligence until the time of their death. And that is brought by the personal representative of the estate of the person who passed away or the decedent. It is not what you think about in estates and trust law. We open up estates for the purposes of litigation only. So what occurs is the family members determine who wants to be the personal representative. Again, this has no bearing on this person gets more money than the other person. This is let's appoint somebody that the family agrees upon, that we can write the register of wills, get letters of administration, and we can go ahead and have that person represent the estate or the pain and suffering of the person that passed. So that's the estate action. That person who passed also in the estate action can recover any medical bills from the time they were injured until the time they passed that are related to the negligence, and any lost wages during that time. That flows through the estate if the case settles, but of course that's going to go to the wrongful death beneficiaries ultimately. Then you have the wrongful death action, which is the people that have been left behind. And statute recognizes those people that can recover for their pain and suffering and loss of companionship, advice, support, guidance, counsel. Those people by statute are the parents of the decedent, regardless if they're 99 years old or 106, the spouse of the decedent, and the children of the decedent, which even if they're adults, they can recover. Maryland changed that law. It used to have to be a minor child to recover in wrongful death. Now you can be a 46-year-old child and you still can recover for your emotional damages and pain and suffering as a result of the person who passed away. So it's the parents, the spouse, and the children. There is another portion to the wrongful death action, which is generally for the spouse, which is the lost wages as a result of that relationship. They have been married, the spouse was making such and such amount of money, still working at the time, was going to work another 10 years. That spouse can recover those lost wages. And then you have certainly something we call loss of household services, which is really an economic analysis by economic experts. A man is 46 years old, he passes away. What kind of work generally is a man at 46 years old doing around the house? And then we have economists put numbers to that. And then we decide based upon what we are told if this is a case that we feel is suitable for the office and that we can help you with. That's the initial intake. If we agree and say, yes, we think that we are a good fit and we can help you, and you all say, yes, we'd like to work with you, we then move on to the phase in investigation. And what happens there is if it's a death case, you have given us, the letters of administration, or you've appointed a personal representative where we can now obtain medical records. We cannot obtain medical records in a death case without letters of administration being filed, because we take those, we send them with the death certificate to the Register of Wills, and we can now get the letters of administration to send out HIPAA forms, which I think people have heard of, but it's basically privacy acts where someone has to sign them to have a release of the medical records. So in the investigation process, we obtain all the medical records that we feel are necessary to evaluate the case. My office, we do things a little bit differently, and I think it's actually a really great way of doing things. I'm very thorough in what I do, and I enjoy reading medicine, and it's something that comes very naturally for me. So instead of just getting all the medical records in and shipping them out to an expert witness to say, tell me if it's a case, I want to read all of the records myself before I send it out to an expert witness, because I want to know exactly what you have been through, what is going on. And when I talk to the expert witness after I send the medical records, I want to be able to have a detailed and intelligent conversation about what occurred in the case, because there's a lot of times they miss things. They're not looking at it. They were just looking at a broad brush where I'm looking at the nitty-gritty detail. So if things are not brought up and they don't bring it up with me, I will bring it up with them. What did you think about this? Did you see the hematocrit on June 6th at 9 in the morning? Shouldn't they have been alerted that the patient was bleeding? So I read all the medical records myself. The next point in investigation, if I believe it's a case, we'll call you up and say, yes, we're going to pursue it further. We're going to send it to these expert witnesses. We have to wait to get their approval before we file a lawsuit, because in Maryland, in order to file a medical malpractice claim, you have to have an expert support it. So we file it, send it out to the experts. My office arranges with the experts to have conversations with me within a 2-week to 6-week time frame. It really depends upon the doctors because they're busy too. I can't control their calendars. And we then get conversations with them. If they say, yes, Julia, we agree with you, it's a case, then we move into the filing of the case stage. The filing of the case is I draft every lawsuit, and I draft the reports for the experts because they're a very simple format that they need to sign in order to get it into a body, which we call HCADRO. It's not the circuit court yet, and it is not where you will have your trial should a trial occur. It is truly a governmental body set up by the state of Maryland, essentially to make $40 and say, yes, now we're going to transfer it into the circuit court. So you have to file in the Health Claims Arbitration Dispute Resolution Office, HCADRO, with a $40 check with your expert certificates and your lawsuit, and they will then take that and transfer it into the circuit court, where in the circuit court, we then, once it is filed, we will get not a schedule yet because we'll get writs of summons back. We have to then serve the defendants. Once the defendants are served, they have 30 days to answer the complaint, which is a general answer. It's nothing exciting. It's standard. It's the same 10 points that are made in every lawsuit. And then we learn who the defense lawyers that are involved. And, we know all the defense lawyers because we've been doing it a long time, and it's the same groups and the same people. And a lot of times I'll get called up and say, hey, I see that we're going to be representing so-and-so. Give me the records you have. I'll give them the records I have, and let's just work together on it, which happens many times and makes the process very simple. It does not have to be adversarial between lawyers. Once we get that, they answer the case, then the court issues a scheduling order, generally 30 to 45 days after the defendants formally answer the complaint. That scheduling order tells the entire process of what we need to do in the case, not the client. Client is not needed. You can be as involved as you want or as little as you want. There are certain things that certainly we need from a client, and which is answering written questions that the defense will send, your deposition, which is certain to occur, which you would be prepped for, of course, by me prior to giving your deposition and then giving your deposition. But aside from those two things, and mediation and trial, should trial occur, client does not need to be that involved. When we get the scheduling order, that order lays out deadlines that the lawyers need to follow. The main ones in that, there's a process called discovery. Discovery is finding out information through written questions that my office will ask you about, or your oral deposition. So that's all that you have to do. We are doing the same thing on the other side. That discovery, we have a discovery deadline set out in that scheduling order that we get from the beginning, and we also get the trial date from the very beginning. So generally in a malpractice case, because they're 2 to 3 weeks long, they're more complex. It's not like walking into a car accident and having a day or two trial. The trial dates are generally set anywhere from 16 to 20 months from the time that we get that scheduling order. It is out of our control. We have nothing to do with it. It is how the court sees the judges that are available, who is going to be able to hear the case, and does the court have 2 to 3 weeks on the docket open for a trial. So in that whole scheduling order, we have a deadline to name our plaintiff expert witnesses. This is more than the people that sign the lawsuit. This is a host of expert witnesses in different specialties that prove not just standard of care, which we have to prove, not only did someone do something wrong, but what they did wrong caused injuries. So we call that standard of care and causation. So we name standard of care witnesses, we name causation witnesses, what they did wrong caused injury, this is why. And then we have damage witnesses, meaning if the person is still alive and suffering from injury, we send out certain experts to assess your injury, and those people give depositions and reports. People that are suffering from catastrophic disabling injuries, such as assume that you have a stroke and you are bedbound or disabled, or you have a spinal cord injury, or you have brain damage, or someone does in the family, we send out different types of experts to come out, assess the patient in person, of course, the family members there. They make a report. Generally, that's going to be a doctor called a physiatrist, which is physical medicine rehabilitation, which is essentially, if you think about it, internal medicine training, that's really a quarterback who brings in different people, neurology, et cetera, whatever specialties they need to improve the function and quality of someone's being as they are, and to see what types of therapies they would need, or depending upon the injury, if it is a brain injured child or adult, generally I'll bring in either a pediatric neurologist or a neurologist to come in and do the assessment. So whether it's a physical medicine and rehabilitation physician, or it is a neurologist or a pediatric neurologist, they make a report. That report goes to my life care planner. And sometimes the life care planner comes out with one of those individuals to do the assessment at the same time. So the life care planner can understand what the physical medicine or neurologist is saying. They produce their report on, okay, based upon this physician, these are the future life care needs of this person from the time they're injured until the time that they are expected, or the life expectancy of this individual. Once we get that life care plan, we send that out to an economist. That economist takes the life care plan based upon the range costs put in the life care plan and reduces that to present value. Although we're not technically required to reduce to present value in Maryland, it's always easier, and most people do. The defense will make us think about it, and then they'll just do it at trial. So it's better just to do it up front so it looks like you're not trying to hide anything. So the bottom line is, once all of that's done and all of the discovery is over, then we go to a process called mediation. This is not required in the lawsuit. However, it always happens in my cases. The defense will reach out and say, look, trial is in 5 months. If we want to get a decent mediator, which is someone there attempting to settle the case, do you want to do a private mediation? A really good mediator is generally a retired judge or a retired lawyer who has experience in trial law. And that usually takes about 2.5 months to get on their books. We sit down, and the client does not have to be involved except to the extent initial greetings, hello. Of course, the insurers want to see what you look like, how you present. They're going to want to see you on the Zoom. The defense lawyers have already met you, but they're going to want to meet you again. And the mediator is going to want to meet you to explain the process and what's going to happen. And essentially what it is, generally it's an all-day process. And we sit in a room, not the client, I'll sit in a room with the mediator going back and forth on Zoom rooms. They'll go to the other people, talk to them privately, they'll bang on them for an hour, then they'll come to me and talk to me privately. So the mediator's job is to tell me everything that's wrong with my case and tell them everything that's wrong with their case. Because the whole point of mediation is they want you to settle, right? And settlement is a good thing a lot of the time. They want you to settle. What is a settlement? They're paying more than they want, and you're probably getting a little less than you wanted, but you're still getting a substantial amount of money. So that is what occurs in the settlement. Ultimately is up to you. Lots of clients have no idea what the range is on certain cases, and I will walk you through that process about what is a good settlement value in a case and whether I recommend it at the end of the day. So certainly by the end of the day in mediation, you will receive a phone call. This is where we are. This is what they have offered. I would recommend you taking it, or I don't recommend you taking it. They're going to come up with more. I know they are. And we still have 2 months before trial, and let's play chicken and see what they do. And let me tell you something, this money's never coming off the table. If they've offered it at this point in time, they're certainly going to offer it when we go to the trial table. If mediation is successful, the process is over. If you choose not to settle the case, then the next step is trial. Trial is something that you would have to be present for the entire 2 weeks, 3 weeks. And why is that? Because this is your case, and you are making people you do not know sit and listen to your case for 2 to 3 weeks, missing their families, missing their jobs, and they will resent you if you are not present. So although it might be an inconvenience, it is something that is absolutely necessary, and it's not something that can, you can come for one day. Trial can be a stressful process for clients because they're listening to information sometime for the first time, things that we have not revealed to you, things that might be disturbing that you don't want to hear, things that might be disturbing that you don't want to hear that you're going to hear for the first time in a courtroom, either from experts or from witnesses that is not information you really need to know, which is why you're probably shadowed from it prior to the trial process. But certainly, if it's something super sensitive, you would be told prior to the time any witness says something that gets on the stand that would be disturbing information that you would not want to hear. But you're there the entire time, and then the verdict comes out, and it is whatever the verdict is. The verdict is. There's a process after that called appeal. I never try a case for purpose of appeal, and what I mean by that is there are some appellate issues that we all know you just don't do, right? And you'd be surprised that defense lawyers, when they get desperate, will sit there and try to throw a trial, try to get an appellate issue because they're afraid they're going to be losing the case. Um, I do not try case on appellate issues. I try the case wisely, and if there's an issue, even if it's an issue that's sexy and a jury be like, wow, if that's going to put us on appeal and make us on appeal for 3 years and have to come back and try this case, I'm not doing it. So I don't try cases with appellate issues in them. When I have a verdict, I know it's a clean verdict. That's the process of once you file your case, investigate your case, and either settle or go to trial.